In the prestigious law offices of Peterson, Smith & Associates, where success rates are high and egos are higher, there exists a peculiar legal practitioner who stands out from his peers. Not because of his Harvard degree, which he ate, but because he's a parrot. Meet Perry Polly Featherington III, the only bird-certified attorney in the state. A former pet shop resident traded his mirror toys for law books and his seed-based diet for courthouse coffee. Perry specializes in bird law, naturally, though his tendency to screech "objection" at random intervals has earned him both notoriety and noise complaints. Supporting our feathered counselor is his long-suffering legal assistant, Sarah Mitchell, a woman whose job description now includes seed cleanup and cracker distribution coordinator. Sarah spent 7 years at Yale Law, only to find herself explaining to clients why their attorney is currently preening himself during consultations. Then there's Judge Hamilton, a no-nonsense veteran of the bench who's seen it all, or at least thought he had until Perry showed up in his courtroom. The judge's attempts to maintain order are regularly challenged by Perry's habit of mimicking his gavel sound and declaring "order in the court" in perfect pitch. The firm's senior partner, Richard Peterson, who hired Perry in what he claims was definitely not a clerical error, now spends most of his time explaining to clients that yes, their lawyer is indeed a parrot, and no, this isn't a practical joke gone too far. Little did anyone know that Perry's unique approach to law, combining bird brain logic with an uncanny ability to memorize and repeat legal precedents verbatim, would turn the legal world upside down. Though his methods are unconventional, his closing arguments often consist of squawking the opposition's words back at them in increasingly accusatory tones, his win record is surprisingly impressive. And so begins our tale of feathers, justice, and the occasional regurgitated legal brief. On this particular Tuesday morning, Perry Featherington III faced his most challenging case yet, defending a local bakery accused of false advertising. The fact that he'd spent the previous hour trying to eat the evidence, a perfectly good blueberry muffin, did little to inspire confidence in his client. The trouble began during discovery when Perry's unique filing system, consisting of shredding important documents into nest-shaped arrangements, led to some rather interesting interpretations of the evidence. His legal briefs became quite literal when he decided that all case documents should be processed through his digestive system first. Sarah had to explain to the judge that "the dog ate my homework" had evolved into "my lawyer ate the motion to dismiss." In client meetings, Perry's attempt at professional decorum was regularly undermined by his instinctive response to shiny objects. More than one crucial negotiation was derailed when he became entranced by his own reflection in the conference room window. His signature move of emphasizing key points by bobbing his head up and down while screaming "where is" and "herotophore" in rapid succession did little to help matters. His preparation for trial was unique. While other lawyers practiced their opening statements, Perry spent hours memorizing legal jargon, which he would later deploy with all the contextual awareness of a GPS system recalculating in a tunnel. His favorite precedent to cite was Polly v. Want-A-Cracker, a case he appeared to have entirely fabricated. The courtroom itself became a theater of the absurd. Perry's cross-examinations consisted mainly of mimicking witnesses' testimonies back to them in increasingly accusatory tones, occasionally punctuated by demands for crackers. His objections, while frequent and enthusiastic, were somewhat undermined by the fact that he objected to everything, including his own statements. During one memorable motion hearing, Perry attempted to submit evidence by dropping it on the judge's head from above, having decided that filing a motion meant literally becoming airborne. Judge Hamilton's new habit of wearing a protective helmet to court was entirely understandable. His time management skills were equally questionable. Perry operated on what his office came to call bird law time, where every deadline was treated as either an immediate panic-inducing emergency or completely ignorable based solely on his mood. Statutes of limitations were interpreted as suggestions, and court schedules were seen more as loose guidelines that could be overruled by sudden urges to preen. Yet somehow, against all odds and rational explanation, Perry began winning cases. Whether it was through his unconventional interpretation of maritime law, everything is technically bird law if you fly over water, or his unique ability to literally repeat opposing counsel's arguments verbatim, while making them sound ridiculous through tonal shifts alone, success found him. His paralegal team learned to adapt, developing a complex system of treat-based rewards for completing paperwork and installing mirrors strategically around the office to keep him focused during client meetings. Sarah even managed to train him to use the paper shredder instead of his beak, though he still insisted on making the shredding sounds himself. The law firm's monthly meetings became exercises in controlled chaos, with Perry's contributions consisting mainly of perfectly mimicked snippets from previous meetings, arranged in what could only be described as legal jazz improvisation. His PowerPoint presentations, while colorful, were primarily pictures of seeds, arranged in what he claimed were compelling statistical patterns. It all came to a head during the now infamous State versus Seedman case, where Perry faced his greatest challenge yet, defending a birdseed company against accusations of selling premium macaw mix cut with ordinary pigeon feed. For the first time in legal history, the phrase conflict of interest involved actual snacking on the evidence. In a moment that would later be dubbed the Great Bird Law Filibuster of 2025, Perry launched into what can only be described as a 4-hour medley of every legal phrase he'd ever heard, combined with perfect impressions of Judge Hamilton's gavel sounds, 3 different ringtones, and what appeared to be the entire opening argument from A Few Good Men, performed in reverse. The prosecution's case quite literally fell apart when Perry, in an unprecedented legal maneuver, began systematically taste-testing every brand of birdseed submitted as evidence, providing detailed analysis through a series of appreciative or disgusted squawks. His expert testimony consisted entirely of eating the evidence and either bowing dramatically or spitting it at the prosecution's table. Remarkably, his unorthodox methods proved successful when he demonstrated that only a true connoisseur of premium birdseed, namely himself, could distinguish the genuine article from the fraudulent feed. The case was dismissed, though the judge did issue a special ruling requiring all future evidence to be submitted in seed-proof containers. And so, Perry Featherington III became the first Parrot to win a class action lawsuit, setting a precedent that would confuse legal scholars for generations to come. The firm's marketing department had a field day with their new slogan, "We win cases by any tweets necessary." The moral of the story? Perhaps it's that justice is blind, but it never specified anything about being bird-brained. Or it's that, in a world of legal eagles, sometimes you need a legal parrot to shake things up. Either way, Perry continues to practice law in his own unique style,